wait until the end of the day, but I figured while it was fresh on your mind, something comes up later, I guess it's not the end of the world. You can make that motion at, at the end of the day, but since the topic is closing, it would make more sense if you did it now.
Mr. Chairman,
Yes, Mr. Co-Chairman.
I would like to bring up the proposals by the Secretary of State's office first as a courtesy. I think we should have bill drafts for all of those.
Okay, it's like it's moved and seconded. Representative Yin.
On maybe what that implementation of, I think the one where it's durational residency, what would that look like?
Yeah, let's pick a time, put something in it, so our LSO has something to work with, 30 days or.
I'm sorry, I was thinking about that one separately, Mr. Chairman. What we could do is look at what other states do, survey that, or we could just come up with a proposal and then work from that, such as 30 days prior to the election rather than registration. That's a suggestion.
May looking very enthusiastic about that recommendation. Representative Yin.
The proposal that you have to verify that it's 30 days before. Or, so you could still register same day,
Yeah,
but you have to verify that it's 30 days.
it's 30 days before you vote. Yep, that's the way I heard it. All right. LSO, yeah, and it's a placeholder just to get the conversation going, and then I think LSO, what I would attach to that is what Senator Case mentioned, which is this survey of what other states do. We had a real brief presentation from the Secretary of State's office with an example of 14 or so states who have altered or created a durational residency, but to know more specifically, what does it look like in the landscape? I think that would be good for us. Okay. Yes. I will take a vote on. We're done discussing it. This is for, I don't know how many, I'm looking back through to see how many bill drafts this is a bill draft for every recommendation made by the Secretary of State's office. So before I call for that vote, was there a clarification anyone wanted on any of the other proposals? We have durational residency requirement. We have the school district trustee ambiguity. Prohibiting private funding of elections. What was the fourth one? Was that it? It's just the three. Okay.
Did we get them all?
Mr. Secretary.
Registration.
Okay. And the special district we'll touch on later. Yep.
So I think the bill draft would be to take the voter registration requirements, the crossover voting requirements from the bill of last year and make them workable, qualified.
Okay. Yep. And I'm getting a head nod from LSO, so they're tracking.
And I think including in that is people that would turn 18, becoming of age to vote in the process past that deadline. Non-resident coming in, all that.
Senator Scott. Yeah. I personally would like to see them in individual bills so we can consider each issue individually. Mr. Co-Chairman.
I think that's good.
Okay. Yes, Mr. Senator Scott.
Wise, but that's too many bills to take to a budget session. So I think.
Well, you'll have to vote some of them down.
Want to consolidate, and I think the LSO needs to know that, as they draft these things, we may well try to consolidate some of them. A
Let's,
lesser number of bills.
yeah, I think we can do a combination of the two. Let's take them all individually. And if all of them advance, we could talk about an omnibus elections bill. That's fine.
Question, can we do them in mass? Consent list, just a question on the bill drafts.
Any
Question.
other discussion? All those in favor signify by saying aye. Any opposed?
Mr. Chairman,
Mr. Co-Chairman.
with regards to the issue of poll watchers or election harassment that we heard from the one person, I don't think there are any real laws in Wyoming. Other states do have laws about how close poll watchers can be, whether they can talk to voters. Can we at least survey what other states do? I'm not asking for a bill draft, but I'm wondering if we could get kind of a flavoring of what other states do in that area.
Okay, get a white paper on that. Yep. Sounds like a good idea. I don't think we need a formal motion for that. Anything else on the elections topic? Representative Yin.
Mr. Chairman, I'd move to bring a bill draft of the Senate Joint Resolution 6 to the committee's next meeting, just so we can figure out what went wrong in the last session and see if we can iron out anything that make it move forward a little easier this time around.
That's the motion. Was there a second? Seconded by Senator Landon. Any discussion on the motion? Representative Ottman would like that repeated. Representative Yin, can you?
Mr.
Restate.
Chairman, it is regarding Senate Joint Resolution 6, political expenditures, where it was talking about undue political influence from money, dark money into elections. And so it was a bill sponsored by the previous Corporations Committee. And I'm bringing it back to see if we can iron out what went wrong in the last session, which is the presentation that Representative Chustik made before we went to lunch.
Further discussion? No discussion. Sensing you're ready to vote. All those in favor signify by saying aye.
Aye.
All those opposed? Let's do it. Raise your hands. All those in favor, raise your hand. All those opposed? Okay, that does carry. Any other motions,
Mr. Chairman,
Mr. Co-Chairman?
in the area of campaign reporting, Wyoming law currently has that if you have to file a campaign report, if you try to influence an election, for anyone except for individuals don't have to do it. But if we join together and buy a signature ad, we have to file a report. I don't necessarily like that, but the fact is that's our existing law. And it's not being enforced. And so my question is, can we do something to make that better enforced? And I don't know if the clerks want to address anything that might have happened. They're aware of this happening around the state. And what happens when you talk to your prosecutors about enforcing that law? And I want to put Ms. Freese on the spot, but I probably shouldn't. I'll put Mr. Irwin. on the
Come,
spot.
yeah, come on up. While they're coming up, LSO, is there a reason why we don't have our screen anymore? The technology that we have a blank screen.
We have
And we-
nothing to say, Mr. Chairman.
I won't be able to see Representative Haroldson. There we go.
Oh, the blinding, look at that.
We can see you now, Representative Haroldson.
It's good to be seen.
Welcome back. Clerks, please.
Last session, you will remember that the previous Campbell County Clerk, Susan Saunders, had testified about a campaign finance concern. That really was more in the area of the federal PAC, impacting state and local races. In terms of enforceability, off the cuff, I'm just going to say manpower. is one. And two, just tracking down those avenues. If an ad gets taken out in a newspaper and it's not reported, essentially you'd have to go through and every expense reported, go through and verify that that ad had been reported. So in terms of enforceability, that's a tough one to enforce, but certainly something we can talk about.
Couldn't you just require individuals to file reports? Just that any campaign expenditure had to be reported? And I understand your self-policing problem, but, or not self-policing, but you policing, but right now you don't police all of the candidate committee, everything that a candidate committee puts in a newspaper or on radio, et cetera. It's brought to you by a third party, right? That brings in a complaint and then you investigate.
Mr. Chairman, Julie Freeze, Fremont County Clerk. So in Fremont County, we did have in the newspaper, I don't remember the exact name, but it didn't say that it was a PAC, but it appeared to be a group that was supporting a couple of candidates. One was local and one was legislative. And so when I asked this person about if it was just one person doing that, which was an individual, usually you don't have to put your name on that. And it was told to me that there was a group of people that got together and they were going to do this as a group, and a couple of people gave money to this instance. And I said, well, really, you should file as a PAC. And I explained that there was a chairman and a treasurer, and this person said, I did not know that. And I said, well, in my opinion, it would probably be better if you just said, I'm the chairman. I didn't realize this. I don't have a treasurer. And these are the three people who gave money, just to be clear on where the money came from. And again, I had, like I said, somebody from the outside had asked me about this. And so I took it to my county attorney in discussions, and he would not support my view on that, although I gave him several statutory citations. And so here's what else this person did. They did try to go on the Secretary of State's website, and if you don't have a chairman and treasurer, it doesn't let you go on, which is ludicrous to me. I'm sorry. Even if you're trying to do the right thing and say, I'm sorry, I didn't have this, but I'm going to report to you, there's no way to do it on the state level. Now, on the county level, this person could have done it, but since my county attorney would not support me in that, it went by the wayside. I still recommended that they file a report, and that didn't happen, and I had to drop that. Here's my point on that, is that I made the flip comment about next time I run for office, I'm going to have my husband go out and get a bunch of friends together, and they can give him money. And I'm going to run under the radar of where I got my money. It could be from corporations. It could be dark money. It could be whatever money you want it to be, but nobody's going to know about it. And so while this person really was going to try to do the right thing, I'm not picking on them at all, but I had a county attorney that did not agree with the way the statutes are written. And I don't know if it's just the way my county attorney interpreted that, but I think you're going to find, I mean, I realize we might be small potatoes, but someday that might not be a small potatoes, and it will literally happen. Like I'm telling you, is that a group of people will gather money, and I'm going to run undetected and say, oh, it's an individual doing it. And it's not true. It's not true. And so I did mention that to Senator Case. I said, is there any way to tighten up this law? And I didn't actually know that we would actually be looking at this, but I'm really happy that we are, because I think it's only fair that the rest of us have to follow all the laws.
I think we can develop a workable bill in this area, particularly if we're willing to make exceptions where everybody's name is on any ad, and where it's over a certain amount, that it then falls under the requirement. I think if we play with those exemptions, we can put together a bill that's workable and enforceable.
It seems reasonable.
Seems very reasonable.
Mr. Chairman, I might mention that my county attorney said the one thing he felt that I just remembered, that he felt that they had not formally organized. because they told me that, they just got in, together and said, hey, let's put some money in and help. And so he felt like they didn't formally organize. I can't remember exactly what the statute says, so that might be another area that you look at that just says formally or informally, maybe it's that simple. That they should do it this way, and then maybe he would have helped me follow through with getting a report, so.
In your case, do you have a formal bill draft motion then?
Well,
What does it look like?
I like the idea of Senator Scott's exceptions. I actually don't want our campaign report to be onerous, but this is a situation where a group can do exactly what a PAC does, and a PAC has to follow the law and there are consequences, and we know all about it. And this is a group of people that can do exactly what a PAC does without reporting. So I think we have to figure out, rather than having a bill draft, we might ask our county attorney to come discuss that, but the bill draft might be the best way to start it off.
I think so. I like having the bill draft because then you have something concrete to ready for the next meeting to look at, even if it's just placeholders.
Yeah, and I guess it would be something like, notwithstanding anything else, any organization that, any group that puts money in a pot to do political purposes, influence elections, shall shall file reports as long as the expenditures are above a certain amount, X. And this is not required if all expenditures and the identities of all the people are disclosed on any campaign materials. It's really reaching out there, but that would be the gist of it.
Getting a nod from LSO, I think we got it. Representative Yin,
And I have one more bill draft thought, if I may.
let's vote on this one real quick.
Okay.
Just to
I was,
stay with our tradition here. All those in favor of the bill draft signify by saying aye.
Aye.
Any opposed? All right, Representative Yin.
Mr. Chairman, thank you. So thinking about durational residency requirements, it reminded me that we actually had a little bit of an uncertainty around a candidate during the last election on what constituted an election, whether it was the primary election or the general election. We seated the individual, so I think us as a legislature agree that they were duly elected. But I think it would be worthwhile to clarify in statute, just so there isn't any uncertainty in the future, what the residency requirement is for candidates. And so it'd be a bill draft just to clarify that specific residency requirement. That'll be a motion.
And Mr. Chairman, can I, following up on that,
Go
Representative
ahead,
Geddes,
Mr. Co-Chairman.
would the gist of the bill draft be that it's at the time of the general election? It's not at the time you take office. It'd be the time of the general election. So you'd be a qualified person at the time of the
Yeah,
general
you could be a
election.
qualified candidate at the time of general election.
Okay.
1 year before.
Any other discussion on the motion? Yeah, Senator Scott. What is, read it to us.
Relevant portion. Who is not a citizen of the United States and of this state and who has not for at least 12 months next preceding his election resided within the county or the district that he was elected. I think that says that the general election is the date.
Representative Yin.
So, Mr. Chairman, I think the underlying ambiguity is whether the primary election was an election where that official could be qualified to be elected. And I think the Secretary of State's office agreed that it is a general election, but I think it's worthwhile to clarify that as a legislature in the state of Wyoming agrees that with regards to Article 3, Section 2, the general election is the election question, not the primary. I do think it's worthwhile to have a clarifying statute, Mr. Chairman.
Further discussion? Okay. All those in favor signify by saying aye. All those opposed? That motion carries. Drafting a lot of bills. Maybe we do need that omnibus election bill. Senator Landon.
You want the hot mic?
Thank you, Mr. Chairman. I thought that Ms. Simmons during public comment made some good recommendations. House Bill 105. I lacking any other vehicle to have it in front of us to take a look at those changes that she recommended. They really look good to me, and I just think maybe we could incorporate those into a bill and take a quick look at House Bill 105. Just some needed cleanup to some of that language.
Is there a second? Seconded by Co-Chairman Case. Then we received an email with what those changes are. Maybe we can just forward that along to LSO.
Somebody did.
Yeah. Okay. Any questions on the motion? All those in favor signify by saying aye. Any opposed? That motion carries. Any other bills you'd like to draft? We've reached our limit for the interim session. We don't need the rest of this afternoon.
You've never been on corporations, but you just moved the bar.
Yeah.
But
Yes.
Too many bill drafts for a budget session. And we're gonna have to start worrying about the burden placing on the legislative service.
These are all fairly small bills. We'll definitely keep that in consideration as we move forward. Thinking about our LSO staff in particular, we don't want to draft 10 bills and then waste the time drafting 10 bills and not moving forward. So hopefully we can figure out how committed we are behind some of these bills before we get too far along. Any other elections, motions, questions, thoughts? If not, we'll move on to our Secretary of State's office. The general update from their office. Thanks, Representative Chesnick. Safe travels.
Thank you, Mr. Chairman. Well, we were asked to provide an update on our business division and where we're at on filings. And we want to start out with introducing to my right, Colin Crossman. And for the record, I'm Chuck Gray, the Wyoming Secretary of State. To my right is Colin Crossman, our new business division director. And to my left is Joe Rubino, our policy director and general counsel. Mr. Crossman, to my right, joined our office in April and brings with him a tremendous amount of experience and expertise in the realm of business law and administration. Mr. Crossman has a law degree from Duke University and is a member of the Wyoming Bar and the Patent Bar. Mr. Crossman has testified in front of legislative committees on different occasions, and since he joined our team in April, he has worked closely with the staff on implementation of Wyoming's business entity filing system and has worked with them to increase efficiencies within the office as we continue to increase filing capacity. And I want to note that our revenues are up 20% year to year and our filings are up 33%. At this time, I will yield to Mr. Crossman for a short presentation and update from our business division.
Crossman.
Thank you, Mr. Chair, members of the committee. As you might,
Like the previous co-chairman, I also prefer chairman, as I'm not a piece of furniture.
excellent.
Thank you.
Thank you, Mr. Chairman. As you might know, the Secretary of State's Office Business Division is the largest single division in the Secretary of State's office. We have 11 staff members and we are currently handling over 500,000 filings annually, and that is growing fairly quickly. As of 2023, the 10th of April, when I started, we had 245,000 new and amendment filings and 257,000 annual reports. We are responsible for the intake of about $36 million annually. We are the primary point of contact for most small businesses, especially new ones that are being formed. And we provide the highest level of customer service compared to pretty much every other state. Delaware, they do a lot. We are second or third to Delaware in terms of the number of filings and the size of our operation, except we only do it with 11 people, whereas Delaware has many dozens. We field over 48,000 citizen phone calls annually and roughly 1,500 face-to-face interactions. And we oversee and audit the commercial registered agents, which is a power we have had in statute for a long time. During COVID, this was not exercised. We have already begun reinitiating these audits as of a couple of weeks ago. A little bit of background on the LLC Act. Wyoming, as you I'm sure know, passed the first LLC Act March 4th, 1977, but you might not realize that Wyoming almost wasn't the first. Hamilton Brothers Oil Company was looking for a way to better hold business assets in an oil drilling environment, and actually had approached Alaska twice with the LLC Act in 75 and 76 without success. Instead of introducing it in Alaska a third time, they brought it to Wyoming, and Wyoming recognized it and passed it with minimal dissent first try. The LLC remained unpopular for about 11 years, and the implementation and the innovation was not well accepted by the IRS or Washington. But in 1988, the IRS formally recognized the LLC and accepted the partnership tax treatment, which was what made it now the most popular and flexible business organization form that there is. It can emulate a corporation, it can emulate a partnership, it can emulate a limited partnership. It can do all of these things. It's the most flexible by far and one of the most versatile, except it doesn't do very well when you're trying to do large scale publicly traded companies, but maybe we'll get there. Further revisions in 94 and 96, as well as every other state following Wyoming's lead, cemented it as such. And I have here on page 6 and 7, the roll call vote of the Senate and the third vote in the House, just to show that effectively it passed with a total of 4 negative votes really quickly, because I think Wyoming realized what they were doing at the time and got it done. Page 8 shows the growth over the last 13 years of LLC filings from 2009, where we're having, these are just new LLCs. We're having roughly 1,000 a month, all the way up to April, where we have, it's looking like just under 14,000 or just under, just above 12,000 filings a month, new LLCs being formed. That is amazing, especially with the way, 11 people in this office, the amount of filings that we're getting just on LLCs. The next slide shows the other entities, same time period by month, and you can see that it's flat. Still a lot, but not the same level of growth. It's because LLCs are what they are.
At it as if we were a business. What is our primary market as we go out, get LLC filings in? Who's doing it? What are they looking for?
Well, Mr.
Crossman.
No, Mr. Chairman and Mr. Scott, Senator Scott, the people are looking for, well, a lot of these are small businesses. And so they're looking for a corporate form that gives them protection so that they're not just operating as a sole proprietorship or general partnership. So in addition to that, they're looking for the ability for them to get an isolated bank account. So for the tax benefits that come with having a corporate form. There are, if you look at that, there are a lot of LLCs that are being formed as what one might call shelf companies, which are being formed in order to be utilized later. Those can be for people who are attempting to start a business and don't know about what they're doing, precisely how they're going to do it yet. Wyoming's statute and Wyoming's process is remarkably flexible and relatively inexpensive. So forming an LLC here, one of the reasons why we are a preferred state for many people is because it is so easy to do it here. By comparison, the state that I came from, North Carolina, the process can take many weeks and is multiple times more expensive than Wyoming. So that's one of the reasons why I think that you see the growth, the recent growth as it is. But if I, as a person who's been in the private sector for 20 years, if I had a growth curve like that for my business, I would be very happy.
Mr. Crossman, do we market ourselves throughout the nation or world?
Mr. Chairman, I don't believe we do any explicit marketing. The commercial registered agents that provide a lot of this ancillary services around corporate formation, they do marketing. But I don't believe the state itself has done specific marketing in that respect.
Senator Boner and then Senator Scott.
Point, is there any way to differentiate if those new LLC registrations are from commercial registered agents or whether they're, I guess, more domestic or more direct business filings?
Mr. Crossman.
Mr. Chairman, Senator Boner, not explicitly, and commercial registered agents doesn't necessarily mean that they're not local and domestic. There are many reasons why a person might choose to utilize a commercial registered agent, even if they are a citizen of Wyoming. One being that those commercial registered agents provide ancillary services such as ensuring that your filings are done properly, on time, making sure that you don't miss, for instance, an annual report and allow your LLC to go stale. Wyoming is particularly aggressive is the wrong word, on the ball to make sure that if someone hasn't paid their LLC fees, their LLC will go stale and become inactivated. Other states can take many months or years beyond the time it should be administratively dissolved before they get around to it. So having those commercial registered agents as a backstop for that is beneficial, and people pay for that. In addition, some of the commercial registered agents out there are attorneys and will provide the operating documents and other documentation to help pay for the deal and make it more viable. But of course, people can do it themselves, and we do see many people come and do it in person without a commercial registered agent.
I speculated there a little bit, but I guess the simple question would be, can you tell how much of that increase is due to commercial registered agents versus not? And is that driving the growth, or is it roughly proportional?
Mr. Crossman.
Mr. Chairman, I believe that it would be roughly proportional. I would have to go back into the data and see if we can figure that out. But my sense is that it is proportional.
I think it would be worth taking a dive into that to see what it looks like, maybe at a future update, because, and I don't know, maybe the secretary has some thoughts on this, but the growth is tremendous and the amount of filings that we have is phenomenal. But there's always been a question in my mind that if we marketed ourselves to the world, how much more could we have? And do we want more? I assume we do, because the 36 million is a pretty nice chunk of change that goes into the general fund. Mr. Secretary, I don't know if you have any thoughts, if you've thought about this at all, but
Mr. Chairman, thank you. I have a little bit, talked with a few former secretaries about potential marketing ideas. Decided I had not prepared anything for appropriations yet. For that, we do have a software possibility that might bring to appropriations. We do, I don't want to ask for more positions. We are, with the increased filings, we're trying to make decision on what our capacity is and whether we need to look at this other software system to help with that. But on the marketing end, I mean, we've kicked around a lot of ideas. It's one of those things that probably will cost some money if you want us to bring some proposals or go through you indirectly and through appropriations directly, happy to do that. But we did kick around some ideas. Just because of the money factor, we hadn't yet put anything on paper for the legislature.
And I imagine, I mean, the 36 million, 40 million, 46 million, whatever it ends up being every year, that dumps directly into the general fund. So
Yes.
in my mind, that's where you would take you would take some funds out of that and create a marketing account for the Secretary of State's office and then try to and then increase that number like tourism, but only a little more successful.
Thank you, Mr. Chairman. I think that's the way you
Just
do
seeing
it.
if, I was just seeing if, I looked directly at Representative Newsom. I was just seeing if she was awake.
That was really.
Go ahead. Sorry, Secretary.
Well, thank you, Mr. Chairman. I think that would be, you're showing your appropriations chops there. That's probably be the way to do it. I mean, I think you would have exponent, it would pay itself for at least itself and more.
Seen advertisements from South Dakota, I believe Nevada, for our competitors, where they have been advertising theirs. And I think it was in kind of journals that might get read by the people making decisions on this sort of thing. So there may be some things we can glean and learn from what's been done elsewhere. Mr. Chairman, my question, bringing all these LLCs registering here, how much other business are they bringing? Obviously, they're employing local registered agents. Are they bringing other forms of business that we have any information as to what the benefits are?
Mr. Crossman.
Mr. Chairman and Senator Scott, the vast majority of them are not bringing specific business into Wyoming. The way we would be able to determine that is the annual report filings. If they have assets in excess of $300,000, they will pay additional fee annually. And the vast majority of them do only pay the $60. So we would be able to figure out to some extent how many of them are actively operating in Wyoming using that metric. But it would still be a fairly rough metric.
Thank you very much, Mr. Chairman. And as I remember that taxation requirement, it applies to companies and taxes them for their assets that are utilized in Wyoming. So if you could have a huge company that's got their business registration here, but they don't have any assets in Wyoming. If you click online, LLC in Wyoming, you're going to be inundated with responses from practitioners all around the country that steer people towards Wyoming. And there's lots of advertising for that. I'm always a little scared of the side of what's our reputation? How are we doing, especially with the connection between trusts and Wyoming LLCs that we've heard a little bit about. So, and this committee, it's actually a revenue committee that discussed it last interim, but 14,000 companies that are paying $60 fees. That doesn't seem like the best business model to me if we don't know anything about how reputable those companies are, what they're doing. So I'm just a little less excited than most people to try to wrap it up and get 50,000 companies a month. I'd like a little bit more requirements about who these companies are and what they're doing.
Nature. We had a provision, I think we've still got it in our statute, where the default provision on an LLC in Wyoming is that the members own it equally, and you can opt out and have ownership in proportion to the number of shares that you own or the amount you put in. Is that, I think that's still law. If it is, tell me, but have we had any problems that we know of because of that particular default provision, or is it working perfectly well?
Mr. Crossman.
Mr. Chairman, Senator Scott, the On the registration side, the Secretary's office does not see how the internal affairs of the LLC are structured. However, to answer the first part of your question, yes, I believe that default provision where members own equally and they're also managers, so member managed being the default, I believe that is the case. And second, yes, through the operating agreement, which is not typically filed with our office, members or LLCs can elect to change that to become manager managed, as well as adjust their ownership percentages internally as they see fit. Of course, there will be issues there, as there is in any business organization that decides to divide ownership. But those are more related to the circumstances of each individual business rather than the default provision itself. We could make the default that ownership is by shares, but then of course we'll still have the same problems of there could still be problems with people arguing over who owns what. So I don't necessarily know if there's a way for us to determine that. Okay.
Back to your presentation, Mr. Crossman.
All right, on the next slide, this is showing, so the previous slides showed the breakdown by month. This is showing the breakdown by the first calendar quarter of each year. It gives a nice smooth graph rather than the much more granular graph previously. And in this, I have included the annual reports. So that gray line with the triangles, if it's in black and white on a piece of paper, that is the annual reports. That's actually where that $60 figure is being driven from. And so Q1 of 23, we crossed over about 70,000 annual reports for that quarter. And on, I believe the next slide, I have that broken down in tabular form. So you can see the 71,000 annual reports in Q1 of 23. In addition, if you wanted to know how many active dissolutions there are, this is where the entity has affirmatively dissolved. That's what the dissolution column is, approximately 2,300 for Q1 of 23. And you would expect that number to grow roughly in proportion to the number that exists. Admin dissolution are when they have either failed to pay their $60 or have failed to maintain a local registered agent of some kind. So those also will likely go up as people just abandon their LLCs. But that gives you roughly an idea of where we are. You know, a pretty big growth over last year from 121,000 to almost 150,000 for the quarter. And so next slide, the filings led by new LLCs are growing very quickly. They're up 33% calendar quarter 23 versus calendar quarter 22, and 47% versus calendar quarter 21. And the total filings are up about 18% in this, over the same periods. Revenues are growing similarly very quickly. For fiscal year Q1 to 3 of 22, that was about 24 million. Fiscal year 23, Q1 to Q3, that's almost 29 million, about 20% increase. And the growth itself is accelerating. We are working to address that growth by identifying efficiencies and deploying tools to assist. Since 2016, which was when you started to allow online filings through the Secretary of State website, each initial online filing had to be manually checked for name suitability. This is not a direct match. So if somebody tried to file Bob LLC and a Bob LLC already existed, the system would be able to catch that. However, our statute requires a higher degree of distinguishability than just that. So plurals, for instance, are not considered distinguishable. So if Bob LLC existed and somebody tried to file Bob's LLC without the apostrophe, that would be considered non-distinguishable. However, that was not able to be automatically classified as such through the online system. So that was done manually. Initially in 2016, this wasn't a big deal. There would be 3 or 4 or 5 every day that had to be checked. When I arrived in April, that had grown to several hundred to roughly about 40 or 50 pages of LLCs that had to be checked every day. So I was able to implement a system that reduced that from between 4 to 6 staff hours a day to approximately 30 seconds. So we've deployed that starting on May 1st, and it has been operating very successfully since then. But the remarkable pace of growth is still there and is going to continue to be there, as Wyoming is a very attractive place for new LLCs. So that is the end of the formal presentation.
Mr. Chairman, why have we seen this accelerated growth? One of our competitors get greedy and raise their fees, or what's going on that's producing this growth?
And thank you, Mr. Chairman. Senator Scott, a couple of things have happened. One, we had COVID. A lot of those graphs aren't easy to see, but on different style of graphing with the different parameters, you can see that there are multiple segments of growth that have changed. One of those segments was COVID. As people were staying home, they were filing more businesses and starting out businesses like that. Second, you are correct. One of our primary competitors did raise their rates somewhat significantly. That would be Nevada. It is, of course, we have Delaware, and they're the big dog. Wyoming and Nevada are neck and neck for place 2. I believe we are pulling ahead of them, partly because they did dramatically increase their filing fees, and we only increased ours a little bit. So people have moved from Nevada. We see a lot of businesses dissolve in Nevada and move to Wyoming. In addition, and I can speak on this from personal experience, Nevada is not the most welcoming to small businesses. And maybe I shouldn't go any further on that one. But I have personal experience on that.
Can I add one thing?
Sure, Secretary.
Yep,
go ahead.
thank you, Mr. Chairman. Appreciate it. I do want to say this system that that Mr. Crossman devised, and it involved basically an algorithm where anything over 80% similarity then gets reviewed. I mean, this was basically turning into something that was taking one of our positions the whole day to do these cross checks. And it was leading to capacity issues. So, I mean, this system that Mr. Crossman has devised to save the state of Wyoming a lot of money and efficiency. So, I just want to note that.
Hopefully that staffer still has a job,
Oh, absolutely. Yeah.
just doing
We're
something
just-
else.
We're just not asking for another position.
Okay, good. Representative Yin.
And thank you, Director Crossman. So I apologize because I missed the select blockchain meeting, if maybe this was asked there, but I know in previous sessions with the previous Secretary of State administration, we've kind of pushed the Secretary of State to implement APIs just to be able to streamline business formation a little bit more. Is that something that you think the Secretary of State's office will try to pursue this time around with this administration?
Mr. Crossman,
Mr. Chairman.
there's a reason why he hired someone with blockchain experience. Gotta be it.
Mr. Chairman, yes, I believe that's accurate. Representative Yin, yes. There is a system that we have been talking about internally, and that system would modernize a large portion of the office. I believe an API system or an API call provision of that does exist for that, or at least other ways of automating it. Clearly, that would be a way of addressing a lot of this growth without having to do things like massively increase the staff. That is and that is a potential solution for that. But as of yet, I don't know what the plans are for bringing something like that forward. Part of it is we have to make sure that that system does actually do everything we need it to do.
Further questions for the Secretary of State's office? No? Anything else, Mr. Secretary? Oh, wait, you have special districts, right? But that's a different topic, so. Mr. Co-Chairman.
And I thank your office, Mr. Secretary, for your online reminders of the business filings that are due. They're really the best. You guys do a great job on it. And, they're timely. They get them before you get past due. I just think you do a great job. Really appreciate it. Thank you.
I thank you. Now we're only an hour and a half behind. See, we're catching up, guys.
House time is just
That's how it works. The next topic we have for our consideration is the regulatory reform topic. We do have a memo from Kelly Lower. If you would please present that memo. Yes. Perfect. We'll bring him in right after this. You can bring him in. Oh, no, you've already brought him in. Welcome, Chief of Staff Perkins.
Thank you, Mr. Chairman.
The goal is we have a brief memo here that we'll hear from, and then we'll turn it over to you. Go ahead.
All right, thank you, Mr. Chairman. This is a memo that outlines regulatory sandboxes in the U.S. It looks particularly at the Utah General Regulatory Sandbox and some challenges and successes that sandboxes have faced across the country. So briefly, regulatory sandboxes allow companies to test products under an alternative regulatory structure. Businesses are accepted into a program to receive temporary relief from specific regulations. And they can gather data on the feasibility and impact of their product during this period, after which a company must either meet the standard regulatory requirements or existing requirements and regulations are updated to meet the needs of these new business models. So these sandboxes provide an avenue for businesses to test new ideas in a real-world setting without the full regulatory burden that would typically accompany such activities. The first successful sandbox created in the U.S. was Arizona's Financial Technology or FinTech Sandbox, established in 2018. Several more regulatory sandboxes have been created across the U.S. These are mostly industry-specific sandboxes, such as FinTech innovation sandboxes or insurance sandboxes. There are a few unique examples as well, like Utah's Legal Sandbox and Wyoming's Medical Digital Innovation Sandbox. Utah's General Regulatory Sandbox, established in 2021, is an initiative of the Utah Office of Regulatory Relief in the Governor's Office of Economic Opportunity. The ORR, Office of Regulatory Relief, has the country's sole example of a general regulatory sandbox, as opposed to sandboxes that are industry specific. The sandbox is open to businesses of all sizes in all industries, although it's particularly well suited to startups and small businesses that may lack the resources to navigate complex regulatory requirements. In the application process, the ORR asks for an overview of business operations from the applicant, the product or services current stage of development, as well as every government agency that regulates their business, as well as specific rules and regulations that they can identify that they need relief from. Some more requirements are outlined on page 2 and page 3 of the memo. Some challenges and successes that sandboxes have faced. A significant variable is how wide or narrow a sandbox is. In other words, whether determining the specific rules and regulations a company needs relief from to operate is the responsibility of the company or the regulators. Narrow sandboxes require that the company determine these rules and regulations and submit them in their application. Wide sandboxes work more with the company and regulatory agencies to figure out these regulations that restrict the operation of the company. For this reason, narrow sandboxes may receive much less usage than wide sandboxes. As of March 2022, about 67 companies had participated in sandboxes across the US. Of these 67, only 10 participated in narrow sandboxes. Several sandboxes in the US have been severely underutilized, if used at all, indicating that the existence of a sandbox does not necessarily equate its success. And possible reasons for this underutilization could be a lack of information about the sandbox, a lack of reciprocity between state sandbox programs, or an unclear or burdensome application process. With that, Mr. Chairman, if you or the committee have any questions?
Senator Scott.
Have any of Wyoming sandboxes been used, particularly the medical?
Mr. Chairman, neither of Wyoming's sandboxes have any participants, nor have they received, they have not admitted any participants as of the state. And we have a fintech sandbox and the medical digital innovation sandbox.
And we almost had an insurance sandbox.
Mhm.
Passed by the House and Senate, but stroke of a pen went away.
Mhm.
Representative Ottman.
Mr. Chairman. Just a background question, because this is very innovative to me. If there are so many regulations governing something that we have to take some of them away, are those regulations something that should be looked at? Or is that for larger entities? Or, I mean, I'm not quite clear on how this works. Thank you.
Mr. Chairman, part of the function of regulatory sandboxes is to see what these regulations are that many of these companies are highlighting as burdensome and assess whether or not they need to be reevaluated, whether these rules or regulations are in fact necessary for companies to operate.
Chairman. So just to clarify, so basically this could be a testing for small businesses to be able to get into something maybe at a lower regulatory burden, but also to check out our regulatory situation in the state to see, to actually be able to look at them and to have evidence of how they're performing. Is that right?
Mr. Chairman, yes, that is one way that regulatory sandboxes could function.
One more follow-up, please. Thank you, Mr. Chairman. Okay, that's one way. So what are the other ways these sandboxes work?
Mr. Chairman, the direct way of allowing startups to assess their environment and see if they need to perhaps conform to the regulatory restrictions. Perhaps they would need to bring in somebody to help them navigate that better. Does that make sense? Okay.
Representative Chadwick.
Mr. Chairman, so who currently oversees our sandboxes? And should we open this up, how would that look? Would there be a need to create an agency? Would it exist within an existing agency? Please go down that road for us.
Mr. Chairman, that could be more of a policy decision. In this example, Utah's governor, the office of the governor's office of economic opportunity, I believe, is the operator of their general regulatory sandbox. I believe the Department of Health operates our medical digital innovation sandbox, and the Wyoming Business Council was set up to receive applications for the fintech.
It's not the banking division,
Yeah. Oh, is the banking division?
so I thought. It's been a while.
Yeah. So in this example, it's the governor's office of Utah. Division of Banking. Thank you.
Madam Chadwick. Okay. All right. I'm sure I think your question also might be better pointed towards Chief of Staff Perkins, so If there are no further questions for LSO, we'll move forward. Sure, all right. Chief of Staff Perkins, the floor is yours.
Thank you, Mr. Chairman. Appreciate your time, Mr. Chairman. Drew Perkins, Governor Gordon's office. I think going back, and I think Kelly did a very good job with her brief. I think that in talking about this, I think one of the reasons you want to look at, and one of the purposes behind these sandboxes are simply to create an opportunity for innovation that is a little bit more free from regulation of established industries. In preparing for this, I've been looking at a number of these things, and the reason, and I specifically asked that your office or that your committee be involved in this one because of a bill that came forward. It was House Bill 214, I believe it was Representative Andrews' bill, which created a general regulatory sandbox. And I thought it was as an idea that was very appropriate. It's an idea the governor is starting on, and we're putting together an opportunity for an effort for regulatory reform across state agencies in discussions with the legislative leadership. The management council's now also created a task force, which I think meets here in a few weeks to have its initial meeting to look at some additional regulatory reform. But one of the policy objectives behind these sandboxes is to create an opportunity for innovation. What we found in Wyoming and what we found in the states that have done these, they're actually quite underutilized with what you might anticipate. I think we've had one applicant, or not even an applicant, one inquiry and some basic information exchange in our medical device sandbox. I don't think there's been any takers whatsoever in our fintech sandbox. But one of the things this becomes important is I think that it's important that if this process of of regulatory sandboxes is going to be a policy objective that will work for states, I think it's important to have some background about what it is that the hope is that we're really chasing. If you go back and look at where venture capital and startup investment happens in the United States, California has, even though California has one of the highest regulatory and tax burdens of any state, it leaves everyone else in the dust. Venture capital investment in California alone typically runs between 50 and 60% of all venture capital deployed in the United States is deployed in California, despite its regulatory and tax disadvantages. If you add two other states, New York and Massachusetts, they count for roughly 73% of all venture capital. Texas, which is, you would think with the high-tech companies that relocate there, they might be a little bit better. They typically have run 3 to 5% and actually decreasing as the share of all market, of all venture capital is deployed. And so I think that one of the things that you've got to do if we're going to be successful in this is that it can't just be Wyoming having a venture capital, or excuse me, a regulatory sandbox, or Utah, or North Dakota, or Arizona. But I think you have to look at creating a wide and broader market, and that has to be able to go across a number of state borders. I know in working on this particular project, I've had discussions with, I believe, 4 other governor's offices in particular, talking about how this would work, about the benefits and the struggles that they've had in their various regulatory sandboxes. And everybody's been a little bit disappointed in how these have turned out and that they're underused. And so to get there, you talk about what we need to do is create a broader market. For example, if we went to have and work with just some of our sister states, Utah, states that are kind of like-minded with Wyoming, Utah, Montana, Idaho, North Dakota, South Dakota, Nebraska, and even Colorado, we could probably present a market of somewhere of 20 to 40 million people, and a market that would be available for innovation and would be broad enough that you could attract some additional investment. And to do that, there's a lot of interest out there in doing that. I know I've had several discussions with Dane Ishihara, who is the director of Utah's Office of Regulatory Reduction. And in talking about that, they were set up with about, I believe, a $200,000 appropriation. That was for 2 staff people to reside and stood up this program in this office inside the governor's office. In talking with the director Ishihara, he thought you could probably start off with 1 would have been sufficient for their needs. But ultimately what they do and what this office does is it contacts when they're contacted by a company, they help contact and run and facilitate these opportunities with the existing regulatory agencies. They also, even though they may not necessarily have applicants to the sandbox, sometimes all they need to know is what regulatory agencies they need to visit with and who in those regulatory agencies they need to talk to. Additionally, they've also found that oftentimes people who are trying to create businesses are frustrated with local, that being county and city ordinances, and that oftentimes a call from the governor's Office of Regulatory Reduction will get a return phone call when customers may not be able to actually get that from the regulatory office themselves. Another, I think, important thing that's happened with the Office of Regulatory Reform or Regulatory Reduction in Utah is it also requires them to have a web page up where anybody in Utah can write in and bring to their attention what they believe to be overburdensome, antiquated, or just excessive regulation, and that they can follow up on those types of things. I think is that one of the things that that Utah has done that it's been it's interesting. The legal sandbox is actually under the auspices of the Supreme Court has had most of the business in Utah, but they are busy there, and they've had some successes in their political, and they've only been at it for just about 1.5 years, going on 2 years at this point. But one thing that they said that we also have to be prepared for is there can be substantially political or even industry blowback as new competitors or new entrants to any particular market may have, at least for a temporary period, a little bit of a competitive advantage in the regulatory arena. And so oftentimes you'll find in particular one, there was a person was granted admission to a sandbox, had to do with home titles and relieve some obligations and some regulation on home title insurance with an effort to decrease costs. That was awarded much to the dismay of many other home title companies, as well as real estate companies who didn't like having the rules change a little bit for that company, even if it was for a period of time. There are other ways to go about that. I think that those are included, and those are actually included in a lot of these included in the bill that Representative Andrews brought before the House last year. And so I would suggest if you're in looking at that, there were a lot of good things. Much of House Bill 214 was taken up and appeared to me directly from what was done with the similar legislation in Utah. A couple of things that I thought I did not like about it, and I think others, it put this in the office, or excuse me, in the Wyoming Business Council, which I think has undergone significant reform in the last few years and seemed to be not necessarily in their wheelhouse. And also, I think you have to keep in mind that the Wyoming Business Council members are usually individuals who are pulled from business community who are established businesses, and in some cases have conflicts or would more likely like to see the status quo maintained. Additionally, it didn't cooperate. It had different timetables and some different periods as opposed to the fintech sandbox and the medical device sandbox that were already in play and in law in Wyoming. But I think overall, I think it's something that this committee, if it's interested in doing this, ought to take a look at. I think there was a good start with Representative Andrews' bill. I think that there are some ways that could be simplified and ways that could be done. I think that it does take at least probably one dedicated person to get underway and to move this forward and to see what it could come of it. With that, those are just kind of the remarks and where I believe that this should run. And again, if we did this, I think it would be important that we're going to broaden this into a general regulatory sandbox, that we'd probably want to have it assume or subsume the fintech, insurance, and medical device legislation that's been offered, some of it passed, some of it not yet. If we were to do this, having one sandbox would probably be adequate. And I think refining some of the concepts that were in there, I think overall it created a great framework. I just think it needed a little bit of adaptation and some scaling down to make it applicable and functional for Wyoming. With those open remarks, Mr. Chairman, I'll stand for questions and we'll see what the pleasure of the committee is.
Representative Yin, no, Senator Boner. You want to go, Representative Yin?
Chairman, thank you. Chief Perkins. I appreciate the idea of trying to incentivize, more business and more innovation in Wyoming. And frankly, I'm disappointed to hear that both the FinTech Sandbox and the Digital Innovation Sandbox haven't really had any authorizations, which are both bills that I voted for. So I think I want that business innovation. But especially hearing from you saying that the venture capitalists are focusing on these states that have much higher, relative to Wyoming, much higher regulatory burdens than we do. Are there other places that we need to look to incentivize business growth other than just regulatory burdens?
Mr. Chairman. I'm waiting. Are you giving me the go ahead, Mr. Chairman?
Yeah, sorry, go ahead.
Okay, thank you, Mr. Chairman. Mr. Chairman, I think I believe that one of the problems that we have in Wyoming is just simply the lack or sparseness of population. And that's why I believe in my opening remarks that if we're going to do this, we're going to be effective, that I think it has to be a network of states, of like-minded states that we cooperate with. I have talked with the chief of staff and the director of the Office of Regulatory Reform and Reduction in Utah. They have interest in doing this. I've had this discussion with Governor Burgum's office in North Dakota. They have interest in doing that. I had a discussion last week with the chief of staff in Nebraska. They have interest in doing this. I believe that if we went down and we found, particularly in kind of the Rocky Mountain and Western states, that if we could accumulate a population of 20 to 40 million people in states that would do this, and if you could find entrance into a sandbox in one state, that would basically create reciprocity, and you'd have to do this reciprocity agreements with the other states, but create the opportunity to operate under that license in any of the member states. I believe that I think you can create the opportunity in a market and a regulatory environment where you can find people willing to take innovation and deal with innovation. That doesn't mean they don't pay their taxes. That doesn't mean they're not licensed, but just having this opportunity to innovate in a little bit less regulatory environment, a little bit less regulated environment, as well as having some facilitation between the economic development prospects that you're hoping for, along with the regulatory authorities. I think that's how you get the synergy to move this forward. And outside of that, I think that Wyoming will always struggle where it struggles, and that is we have a burgeoning population of 580,000 people, and we're not going to find. We can find localized innovation, but if we could find an opportunity to be licensed here and still market and prove up a demonstration offering in Wyoming that was also accepted in other Intermountain states that would have the opportunity to have entrance into a market of several millions of people, I think those are the types of things that would make a difference, not just the opportunity to be unburdened of regulation temporarily.
Follow up from that, Chief Perkins. I'm having a hard time seeing exactly what type of companies might be attracted, that I'm assuming they're not going to be medical tech, they're not going to be fintech, because when we're generalizing the sandbox, what we're really saying is unfortunately, we've so far thus failed with the other two sandboxes. So with a bigger sandbox, we're going to capture different types of companies, or do you have some examples of what those might be from Utah, maybe?
Well, in Utah, a couple of examples you had there was, again, they had one of their first entrants was it was called Homey Title. And it was a title company. And all it really did, the only regulation they really sought relief from was in Utah, they have a requirement that at least 30% of the gross of the revenue of any home title company has to come from an independent source. In other words, realtors can't own title companies and have at least can only have up to 70% of captured income in a title company. So that was an example of where they went there. But other ones that have been successful in Utah, there's also one that created an app that provided for an improved and seamless and quicker response for towing companies. It was an app that could be used from the highway, would create the rotation, an automated rotation among towing companies, depending upon the location and the availability of tows. When people would use the app from the highway, if they were broken down or otherwise needed tow assistance. Same with trucks. So you're doing that. There's, which, doesn't have anything to do with the sandbox, with fintech. I think the high point of many of these is fintech. Fintech is probably the broadest area in which people go. I think that there was some anticipation that our forays into digital assets would create an opportunity for fintech here. There has been some unsuccessful attempts to enter the sandbox in Utah with respect to digital assets. And I think that if we can get our speedy banks off the ground, which is turning to be a little bit more of a challenge than many thought would happen, I think those also create an opportunity where you would find an opportunity, fintech wanting to expand in Wyoming and elsewhere in this area, if we could get our speedy banks under operation and underway with a little bit more success than they've had for various reasons. I'm not sure if that answers your question, Mr. Chairman, but ultimately, I think the message that I believe is that on our own, I think states will continue to struggle with these things outside of California, New York, maybe Texas. But I think that if the whole point is, if you can create a network of states and a market that is sufficient size, that those are the types of things that would attract innovation, because the potential rewards for innovation and new businesses are significantly expanded beyond what would be just available in any one state. Whether you have 500,000 or whether you have 2 or 3 million, you're still limited by market size.
Senator Boner?
Thank you, Mr. Chairman. Appreciate it. Appreciate the discussion about House Bill 214 as a co-sponsor on that piece of legislation. But just had a quick question for the Chief. How he envisions this going, since he did mention moving the administration out of the Business Council. And maybe I missed it, but just want to verify that the idea would be having it be in the governor's office, such as Utah does. So I want to verify that first. And if that is the case, in House Bill 214, it contemplated having the SLIB make any final decisions as to what's approved and what isn't in terms of reducing regulations. Would that change as well, since we'd be, there's already that existing relationship between the Business Council and the SLIB? Would we envision any changes in who approves any potential regulatory changes with the moving the administration out of the Business Council?
Perkins?
Thank you, Mr. Chairman. Mr. Chairman, I just gave the example of Utah being in the governor's office as an example of what Utah did. I don't know that it should be in there. Most places you'll find these in the Department of Commerce. Probably the closest thing we have to the Department of Commerce in our state is Secretary of State's office. That would be another option. You could have it in the Business Council. I just wouldn't make it subject to the Business Council. I believe that the business council and the board that operates, when talk about the business council, mostly talking about, I think, that board. And I think that creates a little bit of a conflict of interest, or I think that those are more entrenched and established business people who sit on that board. And I think they're a little bit less inclined to be as open to innovation as others might be. With respect to most states, what they do is the determination of whether or not and what regulation should be relaxed with respect to a business actually comes out of the agency themselves. In Utah, it goes back to the regulatory agency or agencies to talk about and make the determination of whether or not there should be relief from that regulation for a period of time. That's also where the analysis is with respect to consumer risk or environmental risk or other risks associated with temporarily removing or relieving the regulatory burden. Those things are done actually in most of these states at the agency level who make that determination. With respect to the final determination, I think that it would be counterproductive to actually move that up through SLIB. And I think what you find in Utah, ultimately it's the director makes that, but the director doesn't make that decision to admit someone to the sandbox in opposition to the director of the agency. Using the Utah model, they have an advisory board of individuals who communicate with and who the director uses quite frequently to help him work through that process. And which includes, I think, one legislator from each house, a couple of regulatory agencies, and some external people who look at that advisory council, and they talk about these things. And ultimately, that decision then is made by the director of that office. Now, once that decision is made, a denial is subject to administrative review. But it seems to me that what you'd want to do is you want to reduce regulation as opposed to stack on bureaucracy of having to go to the business council recommendation and then goes to the SLIB, which then makes a decision. I think you want to empower, as an example of what you're trying to do, you want to empower the director of that office to make those decisions with an appeal. Ultimately, that would be an administrative determination subject to the Administrative Procedures Act for any kind of appellate review. But ultimately, you don't want to create a bureaucratic morass for these folks to get this opportunity to have approval. You go back into fintech and the medical device now, those directors have the opportunity to approve or disapprove those in those two categories. Now it doesn't go somewhere else. In this office, you'd want to empower this office to put together those procedures, run it through the process, confer with people, and then make the determination about whether that would happen or not. And he does that in consultation with his advisory board.
Thank you very much, Mr. Chairman and Chief Perkins. It's very good to see you. I'm having a little trouble just getting kind of around the fairness argument. So like, if we have economic development activity and we take and we provide funding for businesses over other businesses, we say that's not fair. That that's choosing winners and losers. That's helping one competitor to do better against another. In this case, we're not giving them money. We're giving them a relief from some regulatory practice. And maybe it's a new type of business and there's nothing comparable, but there seems to be a fairness issue in the case of, for example, I think you mentioned title companies not being owned by realtors. I'm not the biggest fan of title insurance, but never seems to pay when you need it, and and the banks require it. But if you have some companies that can be owned in one way and other companies that can't, is there a fairness between that? Or is the idea that this is temporary to get them on their feet? Or is the idea that this is temporary exploring relief and regulation to see if we can relieve the regulation throughout the universe of Wyoming? And that one I'm really interested in. If we can relieve a regulatory burden on all companies that's unnecessary or duplicative, man, I'd like to get in there with both feet. this funny thing is the regulatory morass is so big, we're gonna do it this way. We're gonna have a sandbox, and if you come into that sandbox, you get special treatment. And maybe the criteria is you're new to Wyoming. You're gonna employ some people, but I'm having trouble with the fairness of it, but I know President Driscoll's here too, and he's got some opinions about that we should hear about, but I'm getting hung up on this. So help me.
Mr. Chairman, I don't, I think it's, that was, I think that was probably the most interesting one that I came across, title insurance, because ultimately, it wasn't necessarily a new innovation. It just relieved a burden that other title companies didn't necessarily have to deal with. So that one was a little bit unique. I think the other thing that you find if you go to Arizona, I think Arizona and also particularly might be in Michigan as well, that not only do you have the ability to temporarily relieve regulatory burdens, you have the ability to temporarily relieve statutory burdens as well, which is an even more interesting concept. But I think that when you're looking at this, these are temporary. So the bill that House Bill 214 that Senator Boner co-sponsored, that had a 24-month. Most of them you find a 12-month period. So it's an opportunity to prove up a demonstration of an innovative idea and be temporarily relieved from that. And most of those have an opportunity for an extension, one extension for potentially in Utah, another 12 months. In 214, it was 24 months with an extension for another 24 months. So the time frame you can talk about. As far as fairness, I think that's important. That's an important consideration in that if you're looking for new or innovative offerings, then I think it's incumbent in both the rulemaking as well as the drafting of the legislation to make sure that you're really talking about innovation. And ultimately keep in mind that if the innovation is successful, that may benefit existing people as well, because that innovation then can take root across the agency once that's demonstrated. So others in the field have the opportunity to take advantage of that innovation once it's been proved up, without necessarily having the cost and outlay of seeing what happened initially during the prove up. So I think again, you can talk about. I think fairness is always an issue, and you and I've had this discussion many, many times, Chairman Case, about letting the market go. I think, and letting the market decide these things. Although what we find, I think it's also important to recognize that in every instance, you are never relieved from any criminal activity that's not specifically exempted. May be a criminal activity to provide a certain type of a financial offering. But as far as fraud or theft or anything like that, those types of things are always are never waived. Additionally, one of the things that are looked at are consumer protection. And so your liability to your consumers is typically never limited. It's not restricted by what happens to you. Those risks are simply identified. Those risks and the regulations, the consumer protection that regulation is generally intended to provide, those things are generally have to be significantly and prominently disclosed to any customer who uses these sandboxes. The disclosure requirements are usually steep and significant, so that customers in these sandboxes of these offerings know what they're getting and know that there are additional risks involved that they may not encounter with more established and more mainstream industries or businesses. So it's a weighing thing. I think you're exactly right, and that's why I brought up the observation that my friend Dane Ishihara in Utah talked about, that there was in some instances when these things were admitted to sandboxes, there was significant political and industry blowback, because in some of those instances, there were many who thought it was not fair.
Suspect, Chief Perkins, that fairness is meant to it's meant to balance itself out over time. I would think that one of the purposes behind the sandbox is if a company comes in or 10 companies come in and they're very successful without regulations A, B, C, and D, then the point is that then we should be responding as a legislature and saying, do we actually need A, B, C, and D at all? And we probably don't if a company was able to operate and consumers were protected, et cetera. So fairness balances itself theoretically out over time as we adjust our regulations to the companies to the companies that are successful. And I don't know, I was going to ask you if we could see that as an example through Utah, but Utah's program is still probably too new because it was just 2021, wasn't it? So we don't know. We don't know if we've seen that play out yet.
Mr. Chairman, I think that's correct. Arizona's been at it the longest. And so Arizona's been at the longest, so they may be a good one to look to. Most of them have been in fintech. I think, I think as Kelly pointed out in her memo, they're kind of wolf. It appears to me that they sound really good, but in practice they've been of limited success. I don't know that that means you don't try it. It's not a major expense to do that, but I believe that I think the approach needs to change a little bit. I think that we would find I would think Arizona, potentially New Mexico, Oklahoma, Colorado, Utah, South Dakota, North Dakota, Idaho, maybe Montana, maybe even Nevada would all be receptive. Nebraska, maybe even a little bit further east, Kansas, Iowa might all be receptive. Basically, us flyover states and creating an opportunity for larger markets, and creating that opportunity to have innovation come. And then, if the business ends up and resides in your state, you win. If it resides in your state, doesn't reside in your state, maybe you don't lose. But if they do business in your state and they've got to register to do business in your state, that's not necessarily a bad thing either. But getting the best products and services for citizens of Wyoming at the best cost that they can get is not necessarily a bad idea either. So Mr. Chairman, I don't disagree with you. I don't disagree with Senator Case. You're all making good points. These things are still relatively new. I guess it's not that much different than PBMs. PBMs are pretty new. There's a lot of information about regulation of PBMs either. But I think you still find a lot of people trying to figure out how to encourage and expand innovation in our states and in our region.
Senator Landon, did you want to chime in?
Chairman, thank you. Just honestly, you just touched on it. I mean, I think you led in a direction I was hoping to go, which is it's been a great discussion, Chief Perkins. It's good to see you. And I do think that more and more as we go forward, this public-private partnership kind of effort is what economic development is going to look like. But I was trying to think, look into a crystal ball and think forward maybe 5 years. If we try this, Chief Perkins, what does that look like in 5 years? And is the end game just to try to find a company that can maybe be successful and that's what success looks like? Or what's the utopian view of 5 years out?
I think the utopian view, Mr. Chairman, Senator Landon, I think the utopian view is ultimately we find out what regulations stifle innovation. We find out what regulations are needed for consumer protection and which ones just seem to get in the way. I think that one of the big parts that should be in any effort is that if this office has ever stood up, that it also creates that outward facing website where anybody can come and talk about regulations that they believe are unnecessary, too expensive, or otherwise burdensome. And those things can be balanced out. I think that you have to go back and look at regulation that we I think the utopian view is you find a place that that promotes innovation, that tries to take tries to find the right balance between regulation and consumer protection, and that fosters a healthy enterprise in our state as well as, but not just necessary for employers, but offerings, services, goods that can be offered in our state at a good price, that provide value to our citizens as consumers. So it's not all just about, I believe, having a business that does it. Those are great. And we want those opportunities for our people as well. But we also want to have the availability of product and offerings we have here. For example, in the one issue that was in House Bill 214, for example, that I think you'd want to expand upon, it required a physical presence in the state. This day and age, why would that be important? Why wouldn't it be a physical or a virtual presence? Why do you have to be physically present in a state? We just heard the Secretary of State talk about these thousands and thousands of businesses that don't necessarily reside here, but they're housed here. The same goes with Delaware. I mean, every major, most Fortune 500 companies are domiciled in Delaware, although they don't have anything there but a post office box and maybe an employee. So it's just part of working with and through the broader markets that we have. Our markets don't understand where state borders are, much less national borders at times.
Senator Barlow.
Good to see you, Chief. Thank you, Mr. Chairman. So my question is, how do you see the regionalization look? Is this a compact type of an approach? Is this just synergy between the states that try to enact similar legislation and provide some of these reliefs, if you will, though temporary, to learn from them? How do you see the regionalization that taking place? Thank you, Mr. Chairman.
Chief Perkins.
Thank you, Mr. Chairman. Mr. Chairman, I see it one state at a time. I think that what happens, I think you'll find, and I think as Kelly's kind of pointed out, that the statutory provisions and these sandboxes are pretty. There's not a lot of difference between them. And so then what you're looking at is, I think you're looking at the states that want to be in that. They'll simply look at those once they're satisfied that basically your sandbox requirements are essentially similar enough to theirs. Then I think you just simply you have reciprocal agreements to recognize, if you recognize our regulatory sandbox, we'll recognize yours. And then after that, you're simply looking typically for no action letters, for example, from regulators. So if someone is in the sandbox in Wyoming, they go to Utah, they simply present that. Utah's got a reciprocal agreement. So the regulator issues no action no action letter if there are certain issues with respect to their regulations that would otherwise be enforceable, but for the fact that this is a sandbox experience. And then also you're looking for interpretive rules that directors will offer interpretive rules about how certain regulations or how relief from certain regulations will be looked at and viewed, so that people know how they go forward. So it doesn't take, I don't think you're looking at a compact, but I think you're looking at reciprocal agreements between states. I don't know that they're that much different than what we do with our licensing now. We do a lot of these types of things with our licensing already, where if you're licensed in one state and you have reciprocal licensing in other states, your licenses can be pretty transferable. In some cases, absolutely are.
Questions, committee? Any other thoughts or anything else to wrap it up? Chief Perkins?
Mr. Chairman, I think that the only.
Actually, I do have sorry, Chief, sorry. Actually, I do have a question. I'm sorry to cut you off. If we were to consider a starting point as a committee, would House Bill 214 be the starting point? Would we just resurrect that bill and then I imagine work through it, or is there a better place for us to start?
Mr. Chairman, thank you. And that's exactly what I was going to say. I think that my ask for this committee, if they're interested in this topic, would be to take up 214 and work that. I would certainly be happy to offer my suggestions, having reviewed that. I would certainly be willing to work with LSO in the initial draft, or at least maybe putting together some draft notes. But 214 has a lot of it. 214 in large part reflects the Utah law, and it's got some differences to it that I think you ought to be taking a hard look at. But for the most part, it's not that much different. And in fact, if you go back, and I think Kelly's probably already done this, I think that you'll find that these are not these are kind of a recipe, and there's a few differences that each state has, but it's kind of a pretty consistent recipe in the 4 or 5 states I've looked at.
All right. Thank you, Chief Perkins. It's been a pleasure having you.
Thank you.
Public comment. Or, yeah, come on up, President Driscoll.
Mr. Chairman, committee, old committee and bring a smile to my face. I'll probably bring just a tiny bit different perspective to it. I think you've covered a lot of ground and you had great testimony. Kelly did a great job of laying it out, and I think Chief of Staff did as well. I look at it and I'm going to background it off kind of where you started, a little regulatory task force coming up. And the reason we're doing this is to make Wyoming a more business friendly state. How do we truly make it where businesses want to come here? And we know, looking around the state of Wyoming, every state surrounding us is doing better business wise than we are, yet we rank #1 business wise on paper in the nation consistently. Why does Colorado bring businesses right across our line? Why does Utah bring businesses right across the line? I live against South Dakota. Why do they bring them in? There's a reason. Businesses come to different places for a reason, and it's competitive. Some of them offer more money. You look at Microsoft, whatever. What Wyoming has to offer, in my opinion, and we've created the model already, looking straight at Representative Olson. The blockchain laws came from nowhere. Wyoming was widely known for not being anything to do with tech. And by the series of laws, we created an industry that's created a lot of those businesses you heard the Secretary of State talk about. One area we've got, Cheyenne's got, I believe, 1,000+ jobs now that are connected with blockchain. You can do it. You create the field and it can happen. And this is one of the tools that falls there. And I think this potential bill is one of the key parts of it. And I encourage you to look really broad. Ask why they haven't been used. Why haven't they been used in other states as much? Folks all ask the question. Generally, when that's the case, is you're not structured correctly to do it. So I'd look really broad about trying to be, everybody worries about the what ifs. We can fix that. That's one thing that Wyoming's got because of the way we meet and we do it. We've all done it before. We've fixed holes. If you want to look at the speedy banks we talked about, we came back a couple of times. We can fix those and we can do it pretty fast. So my whole deal is, how do we as a group, all of us, make Wyoming the most business friendly state? How do we make it a state of innovators, not workers? And that mentality is tough to get around. Utah's really tried hard to do that. Is you can have guys that screw parts on cars, or you can have the guys that design the cars. You know, Representative Yin, it's really being creative about how you go about it. And to me, that's really there. It's not about getting around, back to you, Chairman Case, not necessarily getting around to create an advantage. I'll go back to personal examples, charter schools. I got the heck beat out of me last year because we wanted to make it where they could get around a whole lot of the stuff in the green books. And my answer to that when the schools came at me was, why don't we exempt you guys from a whole bunch of it too, instead of trying to make it restrictive on the new one? And I think that's the way we've got to change our paradigm, how we look about it. It's chief of staff hit it really well. We got to look at that public safety issue. Got to make sure people are safe. We got to make sure that we're not doing an environmental problem. But without that, what part of our rules and regulations are just kind of BS, and how do we get rid of them? And I think you guys can help really make that happen. And it's not about dodging regulations, it's about making them good. Sometimes the business won't come over 2 or 3 lines because it just doesn't work in its law. And a sandbox can kind of work you around that. I encourage you to give them time to work. The 2 that are out there were both created in kind of specific instances for people that were coming. Sadly enough, the one that got vetoed was the one we knew somebody was going to come. If we'd got it signed, we knew a business was going to come. But I think all of these fall in pieces on how you actually attract businesses. And the old businesses, if they're going to come, they're already here. And I'm not so much worried about that. It is back to innovation. And how do we get there? And, you know, all day you guys have gone through it. Business deal. What's made our business filings go? What's made Secretary of State have a 20% increase? LLC. That came out of Wyoming. It was innovation and it was wild at the time. So is the blockchain. And so to me, I encourage all of you to really look outside the box as you write the bill. Make it as broad and well as you can. And if we've opened it up too wide, we'll narrow it back down. But let's really try to look hard on how do we get people to come to this state, because the truth is it's not climate, it's not money. When you look at it all the way around Wyoming on every state that surrounds us, they're doing better at attracting business than we are. And for me, that's what led me to look at the regulatory task force and a couple other things. Is when someone's doing better than you, generally, you better figure out what's going on and figure out how you make the environment better. And that's, to me, is how do we create absolutely the best environment for people to come in Wyoming and still keep what we love. And the other part of it with me, and it's really not a part of this, but how do we keep Wyoming a big open state that we're not destroying it while we're getting these new businesses to come. So I'd stand with questions. Like I said, I don't have any hard specifics, but I have this 30,000-foot view that if you don't fall in that box, you're going to create another sandbox that no cat climbs into. So I'd stand for questions.
Representative Yin.
Chairman, Mr. President, I think you, at that last line, you kind of hit the nail on the head, which is, you know, I think Wyoming wants business growth, but it doesn't want population growth, right? So how do we as a state incentivize people to spend their money here, give us money as a state or business growth, or have people set up businesses here, but at the same time ask no one else to move into the state? Can those 2 thoughts be reconciled together?
Mr. Chairman, Representative Yin, I believe they can, and I think the paradigm's slightly off. We don't want to develop, now it goes back to my last thing. I don't think people of Wyoming want to see urban sprawl across the state. But I don't see huge foot dragging about our cities growing. Cheyenne's growing at a pretty good pace. People aren't going crazy about it. Casper's showing some pretty incredible growth. I haven't seen anybody go crazy about it. The part they don't want to grow, and it's what you folks have negotiated fairly well in your county, is how do you keep your open and wild spaces open and still accommodate the people? And I'm one of the ones, I can tell you, I'm about as tough a guy as there is. I love driving up here and you drive through hundreds and hundreds of miles of no houses and no people. But I absolutely don't have a problem with our cities growing. And that's by cities, I mean little ones. If Hewlett wants to put 2 new subdivisions on the edge of town, I'm supportive of it. If you want to put 2 new subdivisions 10 miles from town out in the middle of a cow pasture or split a ranch up, Adamantly opposed to it. And I think Wyoming, for most of the people that want to come here and develop businesses, happy to come live around these towns. You know, I happen to be friends with one of the ones here in Lander that's developed. Maven's done a phenomenal job of helping Lander grow and helping the community grow around here, yet low impact on the state of Wyoming. And I think we can do lots more of that.
Thank you,
You're
President.
hungry, but thirsty.
Probably thirsty.
Thank you.
Do we have Senator Guru online still? And does Senator Guru want to signed up for this topic? Yeah, let us know. Mr. Winnie, come on up.
Mr. Chairman, Bill Winning. If one goal of what you're talking about here, as Chairman Case talked to, is to find out what regulations and so on are getting in the way and get rid of them, you need to do it, and you need to follow up and keep on it for a while. As a chief engineer and later an executive officer on a nuclear submarine, I saw the impact of rules that just kind of get in the way, rules, regulations, whatever. So when I got to be a commanding officer, nuclear submarine, and then later an intermediate level large repair facility, I spent a lot of time thinking about what do you got to do? How do you get the rules and regulations out of the way of the wrench turners? And you got to keep on it. And so I think this is a really good idea, but there's another step or two beyond it, and you guys are going to have to keep on that. Subject to your questions. Thank you.
Thank you, Mr. Winnie, as always. Senator Guru, welcome. Did you want to chime in on this topic?
Thank you, Mr. Chairman. Good afternoon to you and Co-Chairman Case and the rest of the committee. I've been listening with great interest as a member of the upcoming task force. I've, like I say, just been listening and want to hear your thoughts on this. And as far as chiming in goes, I will. I'm just, the chief talked a lot about, sandboxes, and we've talked about regulatory reform, and we're going to be talking a lot about that this summer on this task force. To me, my thoughts kind of turn inward a little bit towards government itself and talk about how we can change the culture of government to try to help be that innovator. Not necessarily, I agree with the good co-chair, chairman, when he says, I don't want to create winners and losers, and I don't want to necessarily give away the farm to a new business at the expense of an old. But sometimes I think that sometimes inside government, we as elected officials at times don't empower our directors and our staff members to make decisions, to help businesses come to a fruition, or as they like to say it, or I hear all the time in other committees, err on the side of caution. Sometimes we need to back these folks up and create a culture where they want to try to be helpful, and they want to try to know that they can be helpful and know that we're going to have their back on the backside of that. I think those are important things to think about, that we don't necessarily have to walk in, grab a set of green books with a pair of scissors to get this job done. I think the regulatory sandbox is a way. I think empowering staff is a way. I think also helping discipline ourselves to work within ourselves to say, we're going to back our staffs up, and we are going to allow them to make those calls. Sometimes they'll make mistakes. Sometimes they'll get it right. But at the end of the day, what we want to do is make a better Wyoming, bigger tax base, and a better state for all of us. And so I'm not so sure about population. As the president was saying, Cheyenne's seen growth. I'd like to see more growth in Laramie. I think that's a tech incubation center that's waiting to explode. As the Front Range crawls up closer to us, I think that you're going to see that more and more, and we need to get ready for it. And so it's going to take public sector, it's going to take the private sector. We know the public sector does not create business. We government as part of the problem. But I think what we need to do is we need to come together and create a culture where we're working together. And so I look forward to hearing your ideas. I look forward to hearing industry's ideas. I've talked to folks on the first floor at the Capitol and the chief executive and know what they're looking for. And so trying to put that together from that 30,000 foot view is what we're going to be working on this summer. And I look forward to it and be happy to stand for any questions. Thank you, Mr. Chairman.
Questions for Senator Guru? You sounded very much like a member from the majority party with all your talk on deregulation. Good job. Appreciate it.
Thank you, Mr. Co-Chairman. Mr. Chairman, every once in a while, I do like to remind people that there's not as many differences between the parties sometimes as you may think. Thank you.
Good deal. Happy deal. All right. Do we have additional public comment, ma'am? Welcome.
Hi, is this on? Yes. Hi, my name is Karen Wetzel. I'm just a private citizen. I wanted to comment on what was discussed right after we came back from lunch by Senator Case. I am probably the person that he's discussing. I may be one of more than that number, but back in the election season last year, I did run several newspaper ads. I was a person that asked several people if they wanted to come in with me and do that. Nobody did. I did it by myself as a private citizen. I even contacted the Secretary of State's office, and they also contacted the Attorney General's office. I was told I did not need to file anything, that I was fine, and I would appreciate it if Senator Case would stop telling me that I'm breaking the law. That was basically it.
All right. No, that's not how I recall the conversation, but
Well,
I appreciate your.
no,
comments.
in private, he tells me that I'm breaking the law.
All
So- And that's what
Okay.
he's talking
All
about.
right, that's. Thank you, Ms. Wetzel. All right, additional public comment on this topic? No? All right, I will close public comment. Committee, let's go ahead and take a 15-minute break. And we only have one topic left, but might as well get a break, stretch, get something to drink, and then we'll come on back. Here. Yep. We made up a lot of time. Secretary of State's office, welcome back. Special districts. Representative Haroldson with us? No, okay, just checking in on you.
Yep, I'm still here.
You have not converted to Roman soldier yet?
I'm almost there. If you want, I can show you by the end of it.
That would make our evening. Yes, Senator Landon.
Need a
Oh,
any sort of
yes,
action on regulatory piece.
thank you.
Need to interrupt there, but I just want to make sure we didn't miss.
Yep, you're correct. Do we have any motions on regulatory reform?
Go ahead.
Um,
We should do by courtesy, sure.
Yeah, Mr. Chairman, I would just move that we take up, I think it was House Bill 214.
214.
And get another look at it, have it drafted up for the next meeting and work it.
Okay, it's been moved and seconded. Co-chairman Case.
Part of that, maybe it's already been done. Other states seem to have similar things. Could we get a report about what other states are doing? And I bet that was already done for that bill before.
Yeah, probably. And I don't know if there's more that you can tease out about Utah than what we have in the memo, but it's the memo is really good. It is, yes. But it seems to me like if there's a state that we can really look to it, at least from my perspective of what we took in, Utah would be it. So anything else we tease out of that would be helpful. All those in favor signify by saying aye. Any opposed? Okay. And now we're on special districts. We bought just enough time for you to get your presentation up.
State to my left is Joe Rubino, our chief counsel, our policy advisor. He wears lots of hats. He does our media work. So anyway, this last topic, thank you for putting this on the agenda. One of the things I really wanted to do as the Wyoming Secretary of State, and it came out of being a legislator. I always thought the agencies that interacted with the legislature the best brought many of even the small changes, the small situations that were coming up that where the statute just wasn't working. So mixing the bigger reforms and the bigger changes with some of those, and I'd probably classify this in the smaller issue, but when the statute doesn't work, the statute doesn't work, and that's not a good thing. And so appreciate you putting this on the agenda. This was a situation that came to our attention in January. It came out of a special district election where somebody was appointed to a vacancy in a special district, and then the term of office was extended. So, I mean, you could think of some analogies here where, you know, if a House member gets appointed, they go up at the next term of election. Well, in this situation, the individual's term was extended for an extra, I believe, 2 years. And the statute appeared to either be ambiguous or to allow that, which I don't think is probably the intent. Let's go to the next slide. So the fix here would be pretty simple, which would be an appointed to the office of director shall serve until the expiration of the term of the vacancy for which he was appointed to fill. Under no circumstances shall an appointee's term be extended by the directors of the special district. And that's a suggested language. I mean, we're not wedded to anything. And then there's some conforming language there. So wanted to turn it over to Mr. Rubino. He had a little bit more meat on the bone on some of these situations, but this is a pretty basic ask from the Secretary of State's office in terms of a situation that we have had where I don't think the statute is quite conforming to what the intent would be. So, thank you.
Secretary.
Yes.
When I read the blue language, what you're striking out, it says what the red language says. It just says it in a lot less until the next regular election. So what, in that instance that you gave us, what was there a justification as to why the term was extended? Was it failure to follow the statute, or was it failure to understand the statute? Was it a different interpretation of the statute? What was it?
Thank you, Mr. Chairman. I think I'm going to turn that over to Mr. Rubino here.
Thank you, Mr. Chairman.
Go ahead, Mr. Rubino.
Yeah, well, the Special District Elections Act, it interacts a lot with the principal acts of special districts. So you have a variety of special districts that conduct their elections in accordance with their own statutes and also in accordance with the statutes that govern them. So just to name a few, you have 14 here that are listed under 2229-103, special cemetery districts, conservation districts, fire protection districts, flood control districts, hospital districts, improvement and service districts, special museum districts, water and sewer districts, etc. Just to give you a little bit of color on some of the election procedures that we have, 2229-111 discusses formation and initial director election. And so we have the formation of the special districts and the initial election of directors. Then we have subsequent director elections. That's governed by 2229-112. And this gets to your point, Mr. Chairman, a little bit about what you were talking about. This discusses the subsequent director elections. Subsection A says subsequent director elections shall be held on the first Tuesday after the third Monday in March, or on the Tuesday next following the first Monday in May or November, as determined by the district, and shall accommodate staggered terms as set forth in the Principal Act. Well, what we find in some of the Principal Acts is that they set the terms for the term for the vacancy, if it's an appointment, or if it's the term for subsequent director's term. And those can be 2 years, they can be 4 years. I'll read one just from Water and Sewer District. District board members shall serve for a term of 4 years, except that at the first regular subsequent director election following the formation of the district, there shall be elected by the voters of the district 2 members of the board to serve for a term of 2 years and 3 members to serve for terms of 4 years. Thereafter, elections shall be held every 2 years. Each director shall be a voter of the district. Now I'm going to hang on to the Water and Sewer District example for a moment. Right there, you see 2 different interactions depending on which term you're under. So depending on which subsequent election that is, if the election is extended, say the excuse is to get on a regular cycle, so you want to change the election to conform with whatever appointments you have. If you have a 5-person board, and then you have 2 that you want to be on a 2-year cycle or a 4-year cycle, you could, in theory, wait until the next election. And then you could say, well, we'll just have that director that was appointed, they were not elected, well, they'll just go into the next election, and then we can get back on a regular cycle. Our review of that is that the disparity in the terms, the duration of the terms, is that when you're appointed for a specific term. But the statute, as it's written, the next regular election, you could theoretically push it back to the next election if you wanted to play with those elections a little bit. So if it's appointment for a 4-year term and you're 3 years in, then all we're saying is that language should be cleaned up a little bit to where it's the duration of that term, the term that they were appointed to fill, not any sort of term that's then extended because the language currently allows for the next regular election.
Mr. Chairman, the bottom line here is the county attorney in the county in question said that the next regular election was not the election for which was scheduled to occur, and that the language was vague. So we think this is clear. We could bring in that county attorney and ask him, but we think it's clear.
Okay. That answers my question. Thank you. Representative Newsom.
I'm just trying to get clear. So let's say somebody is elected to a 4-year term and 6 months into that term, then they resign or whatever happens, and then there is somebody appointed to fill that vacancy. So then that person would not be in the next election. They would be 3.5 years out. So they would be in the 2 elections away. Is that how I understand that to read?
Mr. Chairman. Yeah, Representative Newsom, yes, that's correct. It would just provide that clarity to where it's the term that you are appointed to fill. And it would go both ways. And 9 times out of 10, this won't affect any.
I'd have to light up your mic there, Senator.
Circumstance where the vacancy occurs after the process of the next election started. Are the definitions such that that election is not the one that counts, but the one after? Because so you have somebody that is, the vacancy occurs after the filing period, for example, for new terms, then you've got a problem if you have to fill it at the most immediate next election. I presume that's handled by definitions elsewhere.
Chair Bino.
Mr. Chairman, thank you. Senator Scott, I think I'm understanding you correctly. And yes, I think that this would help to clear that up. I think elsewhere in statute, we see not references to elections. We see references to terms. And I think that you see that in other contexts, a vacancy that we had in Natrona County just last year, for example. That's what comes to mind. It wasn't centered around the election. It was centered around a term. So you still had to have an appointment by the county commissioners. And again, this is straying into another area, but yes, to be logically consistent, it's revolved around a term, not around the elections. Well, Mr. Chairman, Senator Scott, I don't know that I'd go so far as to say it solves a problem, but it definitely solves that problem. If you're describing a problem, what I'm getting at is that when we start thinking in terms of our statute about the terms and not elections, that's yes.
All right, you good, Senator Scott? All right. Please proceed.
Mr. Chairman, that's all we have on this. One situation we wanted to clear up. Got this came through our office in January. That's what we wanted to clear up in statute, what we brought to the interim committee.
Any additional questions? Senator Scott? Not yet. Still will have some public comment. Just want to make sure we're done with the Secretary of State's office. Representative Newsom?
I want to follow up on Senator Scott's question. And I hope you can clarify for me. So say somebody is on a board, the election is coming up in 10 days, and they resign. And then is somebody appointed right then? And there's no opportunity for the appointee to get on the ballot? So, yeah, would like maybe a clarification of how that would work in that time frame.
Mr. Rubino or Secretary Gray?
Well, Mr. Chairman, thank you. And Representative Newsom, I mean, first of all, you'd have an election occurring at that moment in time. So if an appointment occurred, the election would proceed. I mean, because it says until the expiration of the term of the vacancy for which he was appointed to fill. So the election would proceed because the vacancy expires in 10 days. And presumably that person wasn't running, the person that resigned. If they were, there are other statutes that would kick in then. We're dealing with the specific issue, which was a vacancy that was created in the middle of the term, and then the board decided to extend the period of the term, which we don't think is consistent with the intent of our election code, and to extend terms sort of just on the spot, and to make it conform to a new vacancy that's been filled. But I think this, and certainly, I mean, this is just proposed language. I mean, this exigency, I'm fine working with the LSO staff and with the committee to fix that exigency, but I don't think that's, I mean, if the person who was running and it was the only person was the one that resigned, well, then it would be a new vacancy after they won. And then this would apply pretty well. But for the remainder of that 10 days and that example you gave, I think this would work fine, because then the term would expire at the end of the 10 days and the election is in process.
Wiley?
Mr. Secretary, this instance that you keep referring to, was the person that was appointed, were they challenged in the next election and then not allowed to participate in the election process?
Mr. Chairman, I'm not sure I'm understanding the question right. I don't think the election has occurred yet because the term was extended. And that was the complaint. We received a complaint from someone in the district who said, why is this vacancy that was filled? Why was that term extended beyond the period for which it was initially supposed to be? And so I don't think the elections occurred because the term was extended, and the local county attorney thought that was okay because of the vague statute. I'm using his language, not mine. I actually think the statute's somewhat clear, but I think this is clearer. I don't, and we should bring him in. We can do that as well. It's just initial language. I mean, we're just talking conceptually here at the first meeting, I think, a little bit.
Wiley?
Yeah, Mr. Secretary, that's kind of what I'm getting at. Not that the term was extended, but at the time of the term going to hit the end date, the time frame, was there a challenger for this special district that was just overlooked, or did they just continue the appointment because there was nobody there to participate in the election? Because I know a lot of the times in these special districts, it's people aren't lining up to serve. So that's kind of what I'm getting at.
Involvement?
Mr. Chairman, just to see if I can just get this clear in my mind. Somebody's going to resign and they're on a 2-year term. And so a person comes and applies, they get the 2-year term. And then there is also an opening for a 4. And so they say, well, how about, since we have an opening for a 4-year term, why don't you just take that one? Is that the extension of the term? No?
Mr. Chairman,
Mr. Rubino?
Representative Ottman. Well, I'm not sure that it's that simple. I mean, there are a variety of situations that this could come up in, and that's why I think the language could be cleared up, that we're not referencing an election, right? Because there's several elections that could be referred to. And that's why I think it could be cleared up to the term that you were appointed to fill is what you finish. Referencing a broad election, whether it's a 2-year term to a 4-year term, or, I mean, under subsection A of 2229.112, playing with the subsequent director elections held on the first Tuesday after the third Monday in March, or on the Tuesday next following the first Monday in May, as determined by the district. So that's what we're getting at. When you have a term that you're appointed to fill, you fill until the end of the term. And Mr. Chairman, I think our position is we agree. I think that when we think of the next regular election, definitely in a layman context, we think, okay, that's this term. But when you have some of these that could potentially fluctuate, then you want to go with the duration of the term.
Scott?
So fixes the particular circumstance that they've identified that came to their attention. Where the problem arises with a special district is, okay, say somebody resigns, the election's in progress, they get appointed to fill out the term where the vacancy occurred. But then you don't have a contest in the election because the vacancy occurred too close to the election and wasn't anticipated. And unless in the partisan areas, like legislature, there's a mechanism where somebody resigns and ceases to seek reelection, you have a vacancy, nomination, and the parties can fill it. That is not present in the special districts or for school board or municipal offices, the nonpartisan offices. There needs to be some mechanism so that we know how to deal with the circumstance of not only will somebody need to be appointed to fill out the term, but you'll have a vacancy in the next term because there was nobody to run at the election. Unless you get an adequate write-in, you've got a problem there. And so the question is, what's the mechanism to deal with that? And do we need to put anything in this bill to deal with that circumstance? Because that will eventually happen.
Rubino?
Well,
Secretary Gray?
Mr. Chairman and Senator Scott, that's a great point. I mean, we were addressing this one issue, but if there's some more digging we need to do, just let us know on some other challenges that the special district statute has in cases of vacancies, some other exigencies there. We're happy to help in that draft in that bill. And if there is a motion, if there's a little latitude there, we're happy to help communicate with the staff and with the committee chairman and the committee itself to work on that. There is a deficiency there.
Several possible circumstances. You can adapt some kind of mechanism for filling the vacancy on the ballot and under those circumstances. Or you can provide that after the election, if the term is not successfully filled, then they can appoint somebody to fill the term, the next 2 years of the term to the next regular election. You can do it either way. But I think we do need to have a clear understanding how we're going to deal with that circumstance. Because the number of special districts we have, somebody's going to move out of the district. Somebody's going to have some family circumstance change where they have to resign. They can't run for reelection. They were the candidate. Or somebody died. It's going to happen. A number of them we've got. So we need to have that base covered too.
Absolutely.
Representative Knapp?
Add to this time, but thank you, Mr. Chairman. I actually think the language is good because as Mr. Rubino said, you're dealing with a term. You're dealing with the term, not the election. And I'll use myself as an example. When the late Roy Edwards passed, I was appointed to fill out his term. Now he happened to be on the ballot, did win the election, and I had to be appointed for that extended term as well. They just didn't extend the term. So even if an election's being held, whether they are in the election, whether somebody else gets elected and can't fulfill the term, I think when you're dealing just with terms and that term has an ending, like Senator Scott said, when that next term comes up, there still can be an appointment to that term by the board. That doesn't preclude that with that language. So that was just a comment. Would you agree?
Committee, any other questions? All right, thank you, Secretary Gray.
Thank you.
Thank you, Mr. Rubino. I believe we have Miss Little online for this. We'll bring her in. Do we have any public comment in the room? Okay, you'll be on deck next. Welcome, Miss Little. Go ahead and introduce yourself and let us know what you want us to hear.
Good afternoon, Mr. Chairman. My name is Kelly Little. I am the Executive Director at the Wyoming Association of Conservation Districts. I don't have any specific testimony today related to this, but I was here just in case there were any questions specifically related to conservation districts and the Principal Act and how that interacts with the Special Districts Election Act. So no specific testimony, just wanted to be here in case there were questions.
Do we have questions for Ms. Little? No. All right. Well, thank you for joining us.
Thank
We
you.
appreciate it. Mr. Winnie, welcome back.
Mr. Chairman, you're dealing with a little bit bigger issue than the specifics of
Sorry,
this.
Mr. Winnie. You
Uh,
gotta introduce yourself for the record.
Yeah, Bill Winnie, Sublette County. You're dealing with a little bit bigger issue than the specifics bring to light. And the issue is a board doing something because it can. You may recall in the interim committee discussions, Mr. Lindsay Woolward and Craig Haslam both spoke about an interim topic because they're concerned about special districts having voter apathy. You heard Senator Scott here earlier in the day talk about special districts that were unresponsive. He didn't go into any more specifics. I'm in a special district that turned itself into a de facto municipality. Its duties are about 20 miles of dirt roads, a perimeter fence, and no hunting within the district. And yet they've come out and said they have the authority to alter covenants that apply and run with the land. They have gone beyond their charter or their petition, as I talked about roads and fences and so on. They've refused to open their books, their financial books, until ordered by a judge. And if they want to go beyond their initial petition, the initial purpose of the district, they ought to be required to put it to a vote of the district. And the particulars of this particular issue in front of you doesn't lend itself to that. The legislation is simple and straightforward. But I think you need to look at the bigger issue of boards doing things just because they can pass something. Subject to your questions. Thank you.
Winnie. Thank you, Mr. Winnie. Additional public comment? Any additional public comment? Okay, I will close public comment. Committee, Mr. Co-Chairman.
Trying to make a connection with us, but I think he ended up traveling today. And he has the Association of Small Water Entities, and he has spoke to the committee. I know he spoke to the Senate committee, and he sent a rather lengthy email about the special districts issues that he encounters. And I won't do it justice, but the gist of it is that A special district is formed with a funding mechanism, an authority to issue bonds sometimes or what have you. And that funding mechanism has to be ratified by the voters. So if they get debt, they have to go back to their voters of the district to do that. He is worried about the issue of when the encumbrance on the district is not clearly obvious. And I hope I'm doing this right. Would it be in the case where a district might, say a water district receives funding from the federal government, Clean Water Act or what have you, but it has a contingent liability. It doesn't have an explicit liability. And the contingent liability might come about in case of regulation changes or in case performance isn't up to snuff, or maybe there's some default. And the issue is, do the voters need to authorize the receipt of the grant and the exposure to the contingent liability? And he'd like to propose, apparently municipalities have addressed this issue, and it's the same issue for municipalities, and they are not required to revisit their authorization to accept grants with contingent liabilities. Now, I've probably done a horrible job of representing this position, but that is the basics of what he was hoping that we would take up. And he would like us to perhaps, I think his solution is to allow special districts, maybe particular types of special districts, to accept grants and things with contingent liabilities that may expose the members of the district to pay that without a vote of the people. If I recall, did I do that very well? How do you guys think about that, my Senate colleagues? Senator Scott?
I think I understand what you're talking about. I think it's a separate subject from this bill.
Yeah.
And my question would be, would it be within our charge from the Management Council? So what I suggest is we deal with this bill and then think about, are we going to want to hear more? Are we in a position to take it up, given our charge?
And Mr. Chairman, we did specifically put this in our charge. We had a reference to this particular issue that I'm talking about. I just didn't want us to get away from special districts without looking at this other topic, because apparently he's unable to address this today. So I do agree there's different subjects. The election piece is totally different. It is in the special districts area. We have to decide how to move forward. Maybe just kick it down the road to the next meeting and hear more testimony on this point. I'm okay with that. Where we're at.
It's 5 o'clock somewhere. Senator Landon.
Mr. Chairman, thank you. Chairman Case, I think, did a great job of explaining what the director of the rural water systems was asking us to consider. Municipalities have the ability to pay back, for example, a SLID grant without having to go to voting. And the water and sewer districts do not. And as we sit here today, there are some projects that are hung up pending an understanding of the statutes and the ability to accept these grants. So I think we have plenty of time if we were to just take some testimony in the next meeting, maybe bring that bill in the third meeting if the committee decides to take it up, or if one of the individual legislators does. But so maybe that would be my suggestion, is that we just make sure we have a little spot for it on the agenda in the next meeting.
Senator Scott.
A bill drafted as per the instructions from the Secretary of State's office on this vacancy issue, with a provision dealing with what do you do when you got a vacancy as a result in an election. And that, so that we know how we're gonna deal with that going forward. And ask for guidance from the Secretary of State on that issue.
And seconded by Representative Wiley. Discussion on the motion. Josh, does the second half of the motion make sense? Okay, all those in favor signify by saying aye.
Aye.
Any opposed? Yeah, motion carries. Any additional motions? Discussion? Oh,
I would like us to take up.
yep, let's just make a note so that's on our agenda. And I think that gives us plenty of time to take up a bill draft if we want to. All right. With that, we will stand in recess until 8:30 a.m. tomorrow.
Roman armor as promised.